demolition proceedings started on Friday evening. Started on like yesterday's matter, rally matter. All proceedings are being started from Friday evening. And the court and the concerned and the court having relevant determinations is required to sit during weekend.
The proceeding, my lord, there sufficient notice was given that give instruction.
At least thrice I had to see.
That's a subject matter before another court.
Political leaders, they have started changing their colors. 21 MPs, they are sitting at Delhi, my lord.
And my lord had to also sit on a weekend and dismiss matters also, being frivolous.
Yes.
My lord had to sit and dismiss matters also on Wednesdays, being frivolous. Yes.
CIT road.
So, my lord, it's equally well
Here, my
that way.
lord, I can tell your lordship, now it has come out. In fact, my lord, that was a point I argued before the court, my lord, the coordinate page. That, my lord, when they come up with an application, they have to, my lord, show that there is a plan. That was not there. Now, my lord, the recorded owner was given opportunity, my lord, to bring on record the plan. That was not availed of. Then, my lord, order was passed under the act.
This matter is before another court, my lord. I'm sorry, my lord.
I have pointed out on
Your lordship
with
what did you-
regard to the point taken by Mr. Chatterjee that petitioner is very influential.
Yes, super influential.
Well, that-
Now the merits of the matter is
That
pending.
possibly, my lord, my learned friend will also not disagree that he is, my lord, a super influential.
But after change of political dispensation, how can it be?
My lord, still, my lord. Still.
My every
How
day,
can it be?
one or two
Yes,
FIRs.
yes.
Sir, if your lordship protects my client, then my lord, not by state police, by CISF. This is my instruction.
But I'll just indicate, my lord, I'll just take 5 minutes, my lord. My lord kindly permits me, my lord, 5 minutes. First is, my lord, Shubhendu Adhikari, Sri Shubhendu Adhikari's judgment, my lord, which was cited, or the interim orders which were heavily relied upon. That is not applicable to the facts and circumstances of the case. My lord, may kindly take a note of the fact that in that particular writ petition, the prayers were alternative, quashing, or transferred to the CBI. The Honorable Court considered, and my lord transferred
But
it.
how that is fatal if there is no prayer made for transfer to CBI?
I'm coming to that. my
If I court proceeds on the premise
But-
that there is no prayer,
But an op-
yes, there is no prayer in
lord.
the
I'll come to
petition,
that, my lord.
that
It is there in-
with
it is-
regarding transferring
It is there in the final judgment of that particular case only.
even
there was
the
an-
court can
There was an
consider
objection.
whether interim protection is required.
There
to be
was an
granted or not.
objection. There was an objection as to misjoinder of cause of action, but taken in that case at the final hearing. The Honorable Court said that no, it should have been taken at the inception. Then they would have been directed to file separate petitions, separate applications. But since it is not being taken, or it is being taken at the final stage, and the court is hearing 2 writ petitions and 1 criminal revisional application, the court will not permit a technical plea at such a belated stage. It is recorded, my lord, categorically, my lord, in para 2.2. Thereafter, my lord, internal page 119 of the judgment, and my lord, thereafter, my lord, at para 9.2.
That is the judgment of Justice Sengupta,
My
the
lord.
final judgment.
Yes,
Court is considering
my lord, in that
contemplating
particular.
to pass an interim
Yes,
protection.
my lord, I am taking an objection as
Time
to.
of passing interim protection to the petitioner in that matter, this was not an issue considered by the coordinate bench.
And my lord, in that particular case, my lord, I appeared in that case, my lord. My lord, all the orders, whatever orders were passed, my lord, after consideration of the case diary.
No,
Yes, yes.
I appeared for the state. But there was no question of on verbal submission, my lord, FIRs were state.
Very well.
My lord,
Anything
yes,
more?
yes. My lord, I say, আমি শেষ করে
No,
নিই।
Mr. Chatterjee, please take your seat. Please take your seat. I will hear you later. Please take your seat. Yes.
Now, secondly, since my lord has indicated that my lord is keeping it confined to the 3 FIRs, but I say, my lord, I humbly beseech your lordship,
Yes.
my lord may kindly keep it confined to 1 FIR, because clubbing of investigation or clubbing of FIRs, my lord, by way of filing an application under Article 226, my lord, that is impermissible, my lord, as that results to, my lord.
But in
Highly
other matters which are relied upon,
In Justice Sengupta's judgment, Pradeep Nirankarnath Sharma was not
there are
cited.
a slew of complaints.
I understand, my lord, but the law has been now laid down by the Honorable Supreme Court in Pradeep Nirankarnath Sharma's case, my lord. I kindly appreciate, my lord. This is not a very longish judgment, my lord. It's reported in 2025, volume 4, Supreme Court cases, page 818. I'll just give the paragraphs
Just
to
a
you.
minute, just a minute.
My lord, my lord.
come to the order passed in WPA 25552 of 2022. Dated 8
No,
December 2022.
my lord, I am referring to my lord is referring.
Please come to that.
Orderটা বলছেন interim order বলছেন my lord is referring to an interim order, my lord.
25522 of 2022, order dated 8 December 2022.
Yes. Yes, but that culminated, but that merged in the final judgment. But
Yes.
kindly takes para 33.
Please,
All
please,
interim
please,
orders.
please. There are 13 FIRs which
Yes,
are considered.
yes.
Not only this, no other coercive steps to be taken without leave of the court with regard to
But
other
what-
proceedings.
Yes, but that stood vacated. But that stood vacated. Kindly takes para 33.
And now you are taking this point,
But
Mr. Bhattacharya.
My lord, I am taking the point pursuant to my lord the law laid down.
Yes, that will be considered at the
Yes.
final hearing of this writ petition.
But
not
I am,
now.
my lord, I am on a question
Yes,
of
yes.
maintainability, and my lord, I am in fact.
And your senior has already made submission,
But
Mr.
I-
Raju. So therefore, no further submission.
But only
Enough
one
is
thing, my
enough.
lord.
Yes,
My lord, may kindly, my lord.
Yes.
No, my lord, may kindly permit me, my lord,
hearing
to
is
cite, my lord, a judgment of an order of your lordship only.
Yes.
An order passed by your lordship, my lord. I am relying heavily on that. Etate, Somnath Shamtate. Yes, it's been, my lord, an order passed recently, my lord. It's a judgment, my lord. It's disposed of the writ petition. It's order was passed on 15/7/2026. তাড়াতাড়ি করতে হয়। Yes.
Before my order, I want to rely upon order of the Supreme Court, which you are relying
Yes, yes.
upon.
Supreme Court, my lord, this is the order. My lord, may kindly take a note of the paragraphs, my lord. এইটা একটু দিয়ে দিন, হ্যাঁ। For Supreme Court, the decision, my lord, that I am citing is 2025 4 Supreme Court cases, page 818. The relevant paragraphs are, my lord, para 4, 5, 7 will be important. 8, yes, yes.
Just a minute. First Supreme Court order, judgment.
And this could not have been considered in 2022 because it's in 2025, my lord, that the Honorable Supreme Court delivered this judgment.
Yes, you are relying upon
Yes.
2024 4 SC, 2025 4 SC.
2025 4 Supreme Court cases, page 818. Pradeep Nirankarnath Sharma versus State of-
Paragraph.
the relevant paragraphs are, my lord, para 4, 5, 7, 8, 10 to 17, my lord. The ratio is, my lord, the first is, my lord, there cannot be a blanket protection. Second is, my lord, there cannot be several FIRs which can be heard together, which can be heard, clubbed and heard in a single matter together. So, my lord, this is the law, my lord, which has now been, my lord, and
Which paragraph it has been held?
my lord will find it in,
Take me to that particular paragraph.
my lord. My lord, kindly takes. There also, my lord, it was concerning, my lord, national resources, land allotment, etc. So, yes. My kindly takes, my lord.
Just.
My lord.
Yes.
Yes, my lord,
Yes.
kindly takes para 11.
11.
Yes, I can skip over the facts, my lord, which are recorded above that, my lord. Now, kindly takes it up, my lord, from the third line, para 11. It was submitted that the appellant has sought a blanket order directing the authorities to conduct a preliminary inquiry before the registration of an FIR, which is impermissible under the settled principles of law. It was further contended that under section 154 CRPC, the registration of an FIR is mandatory if the information discloses the commission of a cognizable offence, and the police have no discretion to conduct a preliminary inquiry except in limited circumstances as laid down in Lalita Kumari. The state also asserted that there is no statutory provision requiring the accused to be given an opportunity to explain his position before the registration of an FIR, as such a practice would amount to granting an undue advantage to persons accused of serious offences and would hinder the investigation process. Additionally, it was argued that the appellant's plea, if granted, would set a dangerous precedent wherein public servants accused of corruption or misconduct could claim immunity by demanding a pre-FIR hearing. The respondent further contended that adequate legal safeguards are available to the appellant under the existing legal framework, including the right to seek anticipatory bail and the right to challenge malicious prosecution before the appropriate forums. Thereafter, my lord, para 13, the second line, the legal position regarding the registration of FIRs in cases of cognizable offences is well settled. This court in Lalita Kumari has categorically held that registration of an FIR is mandatory under section 154 CRPC if the information discloses the commission of a cognizable offence. Now, my lord, may kindly skip over and come, my lord, straightway to para 14. The scope of, my lord, may kindly skip para 14 also. It was pertaining to preliminary inquiry. Yes. Para 15, in the present case, the allegation against the appellant pertain to abuse of official position and corrupt practices while holding public office. Such allegations fall squarely within the category of cognizable offences, and there exists no legal requirement for a preliminary inquiry before the registration of an FIR in such cases. Para 16 will be important. The appellant's contention that successive FIRs have been registered against him with an ulterior motive is a matter that can be examined during the course of investigation and trial. The appellant has adequate remedies under the law, including the right to seek quashing of frivolous FIRs under section 482, the right to apply for bail, and the right to challenge any illegal actions of the investigating authorities before the appropriate forum. In para 17, further, this court cannot issue a blanket direction restraining the registration of FIRs against the appellant or mandating a preliminary inquiry in all future cases involving him. Such a direction would not only be contrary to the statutory framework of CRPC, but would also amount to judicial overreach. As rightly observed by the High Court, the courts cannot rewrite statutory provisions or introduce additional procedural safeguards that are not contemplated by law. So,
furthermore, this court cannot issue a blanket direction restraining registration of FIR against the
that is his final relief
and mandating a preliminary inquiry in all future
cases. That is what he has sought for in the
case.
He has said that no registration of FIR without leave. No, that is the prayer.
It is considering that whether petitioner is entitled to get interim protection, not to take coercive
But para 16 is the
not
answer.
to take coercive steps during continuation of investigation.
But that, my lord, is, my lord, again, my lord.
Your paragraph 7 makes
Para 16,
the
my lord.
distinction.
No, para
It
16.
says further this court, I am very slow person in reading judgment, Mr. Bhattacharya. Please, further this court cannot issue a blanket direction restraining registration of FIRs against the appellant or mandating a preliminary inquiry before registration. Whether this case is akin to the case which was considered in the judgment reported in 2025 for SCC.
But para 16 is the answer again, my lord. That
I need not go further.
para 16, my lord, says that the regular recourse.
It is relating to registration of FIR and preliminary inquiry prior to registration.
16 is during the investigation. During
And here already registered FIRs are registered. Investigation is going on. Court is considering whether petitioner is required to be taken into custody or not, or any coercive steps are required to be taken. If order is passed, directions are given, ensuring cooperation of the petitioner with the investigating authority. How that judgment is applicable?
Then comes my lord's order passed in my lord Somnath Sham's case.
Yes,
that I have handed over.
No, I need not consider
my
my
lord.
own order
Para
after
7.
this judgment.
No, para 7, my lord. Para 7 of Somnath Sham, my lord has relied on Niharika. And my lord has refused, my lord, the relief claimed for and dismissed the writ petition.
Yes, concluded.
My lord, only one thing, my lord. I just repeat, my lord. My lord, may kindly pass an order upon consideration of the case diary, my lord, in these 3 cases, or my lord in the alternative, my lord. And in so far as the Bidhan Nagar case is concerned, that my lord is relying upon, my lord, the order passed in May 2026, my lord. There, my lord, all sections were, my lord, up to 7 years, my lord, maximum punishment. But here, in respect of the Diamond Harbour Police District, my lord, 2 cases are beyond 7 years, my lord, the sections.
Yes.
So my lord may not pass that order, my lord, without my
this
lord
court
appreciation.
cannot rely upon 35(3).
No, 35(3) was applicable in that case. So there is already an
So
inbuilt
here
protection.
35(3) is not applicable.
No, here 35(3) is not applicable. This is one, my lord. My lord may kindly consider, my lord, Bhawanipur. My lord kindly considers one FIR, not multiple FIRs together, my lord. And that is my humble submission.
That is a statement made on X handle. That is a statement made on
Yes, the
X handle.
Bhawanipur police
Yes.
station case, my lord. The Bhawanipur police, and my lord, one more thing, my lord, in these both these cases, my lord, in so far as Diamond Harbour Police District is concerned, since, my lord, there was a delay, my lord, preliminary inquiry was duly conducted, and thereafter, my
These are
lord,
all Mr. Bhattacharya in connection with election campaign.
election.
Election campaign.
No, it was not with election. Diamond Harbour is not with election.
No, Bhawanipur.
Bhawanipur was with, my lord, it was a hate speech, my lord, which was given. But my lord, Diamond Harbour, both the cases where it's more than 10 years, more than 7 years, my lord, there was preliminary inquiry. My lord, there was a question from the Honorable Court as regards the delay. But there is no delay in so far as registration of FIR is concerned. There is a delay in so far as the reporting of the incident is concerned, my lord. But there, my lord, following Lalita Kumari, preliminary inquiry has been done. So, my lord, may kindly pass orders, my lord, if the Honorable Court is minded to pass any order, my lord, may kindly do that upon consideration of the case diary, my lord. Kindly direct me to produce the case diary.
Already investigation is started. Preliminary inquiry.
Yes.
The court is not considering the prayer of the petitioner
No, it
that
is
whether preliminary inquiry was required or not.
It is illegality, irrationality, and procedural impropriety. My lord, exercising my lord, powers, my lord, following the Wednesbury principle, my lord. I am on a more fundamental
Court
aspect.
is not, because you have crossed that hurdle. Preliminary inquiry is over, FIR registered, investigation going on.
But then Niharika will apply.
Even if there is a prayer made in this writ petition with regard to preliminary inquiry, that is not even considered. I am telling you.
With the deepest of humility, my lord, then Niharika will apply, my lord. But he can seek for a bill, for an anticipatory bill, in the event he apprehends, my lord, coercive action or arrest, my lord.
But what about Haji Iqbal?
No, Haji Iqbal is there.
What about paragraph 102 of Bhajan Lal?
But no, 102 is different, my lord. 102, his case, my lord, even if we go by, my lord, the judgment of, my lord, Sri Shubhendu Adhikari, Sri Shubhendu Adhikari's case was, my lord, malicious prosecution. Here, my lord, they have only alleged, my lord.
There are judgments in appropriate cases by the Honorable Supreme Court. Now, this court has to consider that what are the, considering the facts of the case, which one is applicable.
But for ascertaining the facts of the case,
judgment,
for ascertaining the facts of the case,
but at the time of Mr. Bhattacharya, I am telling you, at the time of, though this court has initially expressed hesitation at the time of hearing of this matter, that whether the FIRs where particulars are not disclosed, or whether the multiple affairs can be gone into in one writ petition seeking quashment of a proceeding. But I have come across several orders passed by coordinated bench in other matters where more than 10, 15
Yes,
FIRs were taken into consideration. Not only this, no other proceedings without leave of the court.
But Pradeep Nilankarnath, my lord, was not considered. Pradeep Nilankarnath, my lord, I have taken your lordship to para 16, my lord. And my lord, the Honorable Writ Court, my lord, it's a discretionary jurisdiction.
Yes,
482
Mr. Chatterjee, what you are trying to, I understand.
One thing, my lord. Number one, my lord. Sri Shubhendu,
Yes.
I'm not touching his submission. This is my own submission.
Because Mr. Chatterjee was trying to.
My lord, only one last, my lord, submission, my lord, I'll make, my lord, for my satisfaction, my lord. But the Honorable Supreme Court, my lord, Haji Iqbal, my lord, has one aspect. But the Honorable Supreme Court, my lord, says in 2012, 10 Supreme Court cases, page 155.
In Haji Iqbal, paragraph 14, it is observed that attending circumstances need to be taken into consideration.
Yes, but again, 2012-10 says the Honorable Court cannot go into, or the police has no discretion to see who is the de facto complainant. The police has no discretion to verify the antecedents. The duty of the police is, my lord, to have a look at the FIR. If it discloses a cognizable offence, there is no other discretion but to register.
FIR has to be registered.
And, my lord, the Honorable Court, my lord, in exercise of powers under 226 or 482, my lord, it cannot go into, my lord, a mini trial before, my lord, evidence is collected and, my lord, the investigation. Oh, I understand. My lord has indicated that. My lord has indicated that.
No observations with regard to the
My lord has
contents of the
indicated
FIR.
that. My lord has indicated that. I'll just.
It will influence the investigation.
My
And
lord, I am, my lord, I am on a more practical, my lord, angle, my lord. Now, my lord is saying, my lord, that he will cooperate. I'll put him to terms, but don't take coercive actions. he will go there, he will sit, he will say that very well, I am cooperating. This is my cooperation. I am here. I have presented myself. After my lord a week, he will come back. My lord has taken judicial notice, my lord, of my lord the
Court passed order in similar
no,
situation.
past orders, and my lord has seen, my lord, the present indifference, my lord, insofar as, my lord, even, my lord, the proceedings before the honorable court are concerned, my lord. He also, the honorable court volunteered to send him to, my lord, a medical board. It was a very simple thing. He was, my lord, he did not even have, my lord, the, my lord, minimum decency also.
I would not make any comment because there is
No, it's my submission. My lord may not make any comment. My lord may kindly appreciate. Even despite orders passed by your lordship, my lord, the state had to come up by way of an application to direct him to cooperate for collecting voice sample. So what he will do? Yes. So, my lord, I am on a more practical aspect. After a week, he will come back and say that see, I am cooperating. The police has called me. I have been there. Now they are harassing me. So, my lord, the investigation.
It does not anticipate the problems which may arise.
No, my lord, this is
Then
the.
will come up. Then you approach the court seeking.
But this will happen.
Let us not anticipate.
No, this will happen, my lord. This will happen, my lord.
Yes,
Otherwise, my lord, but this will never stop, my lord. The
In that
226
application,
was-
subject
So
to what my learned friend
when
is
you
saying.
want to stop it,
my lord,
when you want stop it,
but it has to be a meaningful cooperation. He cannot go and
up to
sit
this
alone.
only,
He cannot go and
up to
sit.
this only, not beyond.
No, but at this stage, my lord, without looking into the case diary, my lord may not pass, my lord, the orders, my lord.
Yes. Yes.
Lines, my lord, without touching Mr. Bhattacharya's submission.
Never ending.
Mr. Shubhendu Adhikari's case is not at all applicable in this case because Mr. Shubhendu Adhikari, while he was opposition leader, he was attacked 30 times. 30 times. And my client, he was attacked 4 times.
No,
my lord,
that case will not set an example so far present case is concerned because the circumstances are different. You are absolutely correct. But the order passed in those matters are being relied upon whether in one writ petition multiple FIRs can be considered.
Absolutely.
Not beyond that.
My submission is.
You are absolutely correct. The facts are completely different.
And my lord, I have also lodged other complaints wherein there are complaints regarding Shebas Roy. In Shebas Roy complaint, my lord, your lordship.
No, this is not the subject matter of this writ, my lord.
She has lost her leg.
Let him make submissions to confine to this writ only.
PCPNDT acts are also there, my lord. So, my lord, if your lordship passes or not, I do not know what will fall from your lordship. But my lord, kindly.
That is pending. Lordships can take that
Whenever
matter.
necessary, if police calls him, he has to attend the police station. And my lord, this should be the prayer from state government side. If he does not cooperate, then liberty should be given to us, at least to my lord, modify the order, my lord.
Us.
Liberty should be given.
To the de facto, my lord.
Cooperate, my
Leave
lord.
the de facto.
Come before your lord.
Only
Point
one
of
thing.
question,
But
we shall-
I have,
My lord,
if
may
I,
kindly,
if I can just take 2 minutes, just 2 minutes.
and my
Just
lord,
to-
only one thing, my lord, may kindly go through the pleadings, my lord. These are all on surmises and conjectures.
Yes, Mr. Shankar.
Yes.
But I'll just hand my lord list, my lord, indicating, my lord, the ratios on which I am relying upon, my lord, the compilation, my lord.
I will just take 2 minutes, my lord.
Yes.
Very briefly.
Yes.
Para 102 of Bhajanlal, your lordships have read with reference to both Article 226 and 482. That is what I'm relying on. Second, the cooperation aspect that they have made much of. Please note page 14 of my writ petition, where I have mentioned the instances of cooperation by me, where I have gone and I have been interrogated for extensive periods of time. That's at page
Again, a
14.
misstatement, my lord. I indicated that on the first occasion.
Just a minute, allow him. Allow him. He did not obstruct you. Mr. Bhattacharya, please take your seat.
There's no seat.
Please take your seat. That is not the way to address the court when elaborate submissions are being made. And you are an additional advocate general.
Page 14 bottom has a table, my lords.
Yes, cooperation by petitioner, you are relying upon
Yes.
page
14, bottom of page 14. That was up till the
of writ petition.
of writ petition.
Just
Page
a minute.
14, 1-4.
Hey, writ petitioner copy to the. Yes, page 14.
Yes, I just want to draw your lordship's attention. I'm not reading it out, just the table. Your lordship will
Yes.
see the table at the bottom. That
Yes.
shows the cooperation that is taking place. We undertake, of course, to cooperate with any of the investigation. I'm not pitching it that high that I'm saying stay of investigation, etc. at this stage. I'm saying that we will join. There's no issue with that at all. So I don't think that apprehension needs to be there. The third point, Manoj, is that my friend, the Lord Additional Advocate General, has repeatedly said that that 8th December 22 order in Mr. Suvendu Adhikari's case was an interim order and that has been vacated. I don't think that expression is correct. It's not been vacated. In fact, of the FIRs that had been registered against Mr. Adhikari, 2 had been withdrawn, 13 came to be quashed. So that works in my favor, in fact. The interim order goes halfway.
What is your contention? 8 December 2022 order passed in the case of
Mr. Suvendu Adhikari was an interim order, is the argument taken against me, saying that it got vacated. It did not get vacated. In fact, the final judgment held completely in Mr. Suvendu Adhikari's favor, and it quashed 13 FIRs. 13 were quashed by that final judgment. Para 9.3, your lordships will recall, I read to your lordships last time, on the reasoning as to multiple FIRs in a single writ.
Yes.
So
that is the judgment of Justice Sengupta.
Yes, my lords, absolutely. Of 24th October 25. I'm saying this
Consecutive paragraphs were relied upon,
Correct.
one by on behalf of the state and another on behalf of
one by me.
by the petitioner.
9.2 and 9.3. Those
Yes.
are the 2 paragraphs. I'm just saying that it's improper to say that the interim orders were vacated. Interim orders were in fact absolute, confirmed, and the underlying FIRs were quashed. 13 FIRs were quashed. 2 were in fact withdrawn by the state, and 1 the court did not interfere because Mr. Adhikari was not an accused in it. So they said, at your instance, we're not interfering because you're not an accused in it. I just want to give you the true picture. 16 FIRs, 13 quashed, 2 state withdrew, and 1 there was Mr. Adhikari was not an accused. Right, Manoj? Third, on these 2 judgments that they've cited before your lordships, I don't think either of them apply. But the Somnath Sham order of your lordships, I think, was referring clearly in paragraph 4 to the question of whether there has been a violation of any fundamental rights, etc. I think that question doesn't arise
With a
here.
copy of this order, my order,
Yes.
from Sham,
I've handed over.
that you have handed over.
Yes, yes.
Yes.
The compilation, part of the
But the compilation, it's a part of the compilation.
Filed on behalf of the petitioner.
No, it's filed just now, madam.
Is order dated?
It's the order dated.
Yes, Somnath Sham.
Yes,
order
yes,
dated
Manoj.
15 July.
15 July.
Right.
Just see the argument of my friend Mr. Bhattacharya Malad, which your lordships accepted at para 5. The argument was that unless a case is made out alleging violation of fundamental rights, writ court, while exercising jurisdiction, may not entertain writ petition. This was not a case where there was a 5-year delay. This was not a case where a political opponent had filed the case. This was not a case where 16 FIRs had been registered. And this was not a case where the FIR was registered immediately after the election results were declared. There are 4 factual points of distinction, which brings me to my arguments on Article 14 and 21. Therefore, this order, my lords, which was in a singular FIR, not a pattern, not dealing with electoral enmity, cannot at all be pressed into service against us. This, and the other point is, in that Somnath Shah's case, my lords, there were criminal antecedents. My instructions were, there were 10 criminal antecedents at least that Mr. Ichini Somnath Sham had, which is not the case in our case at all. There's 0 criminal antecedents. Nil. Mr. Bhattacharya, let me finish.
I didn't say anything.
You said, my lords.
Yes, Mr.
And then finally, on the Supreme Court's order, which was relied upon, my lords, by just now. That was an order of the Supreme Court dealing with where a preliminary inquiry was sought mandatorily from a 226 court, and two, I'm sorry, what's the name of the judge?
Yes.
Yes. What's the name of the judge?
That is 2025 4 SC 818.
Correct. Pradeep Nirankarnath Sharma. But in that, the prayers made by the petitioner after the High Court had dismissed his plea, the prayer was that in every case you will have a preliminary inquiry when it concerns me.
That is what I have told Mr.
Exactly.
Bhattacharya
Yes,
in
my lord.
reference to the observation made in paragraph 17.
Absolutely, my lord.
With regard to preliminary inquiry and registration of FIR.
Correct.
And
And
stage is over so far the present case is concerned in all 16 FIRs.
yes, my lords, absolutely.
Court is considering 3 FIRs.
I am most grateful. Now, one last point, my lords. That chart which was handed up to your lordships of those 16 FIRs, if your lordships could take that.
Yes.
One page.
Just for the purposes of clarity, my lords, I suspect we will be troubling you with that chart even
Just
on future occasions.
Supplied by them.
আমি তো single page দিয়েছি একটা।
Yes, the single page with 16 FIRs listed on it.
Just a minute.
Yes.
Probably that one, Malad. Yes, this one.
Yes.
Yes.
I just, for your assistance, if your lordship could just mark in the margin, serial numbers 2, 3, and 12 are the subject matter of this writ.
Right.
2, 3, and 12. But separately,
2, and 12.
See, 2, 3, and 12. Separately, serial numbers 6, 7, and 11. 6, 7, and 11
Yes.
are subject matter of the other writ listed today, my lords. Writ petition 19982, which is at serial number 93 of your lordship's board. That is 6, 7, and 11. The interim orders which the court has passed in the past, protecting me, my lords, has come in serial numbers 13 and 14. Serial number 13, because your lordship was asking this query, I just wanted to help. Serial number 13 is the one in that revision proceedings that's dated 11th June 26. If in the margin your lordships could jot down, 11th June 26 is for serial number 13. And serial number 14 is 21st May 26.
So in this writ petition, you are questioning serial number 2, 3, and 12.
Absolutely.
Yes.
The other writ on your lordship's board is dealing with 6, 7, and 11. The interim orders which your lordships have passed is in 13 and 14.
Up to 17.
For this, Malad. For this up to 17.
Yes. So in this matter, your lordships have extended up to 17th. My plea, my lords, today is to make that absolute until the matter is disposed of.
No, what I have thought that this
Yes.
matter will come because it will take some time to dictate order. So this matter will come under the heading for order for passing an order, and up to that extent, and that's why there will be further extension of interim order, which was passed on earlier, which is subsisting.
Maybe we have
till
filed a
17th.
can for this.
Yes.
Till further orders, then, my lords.
Yes.
Can,
Yeah.
can one,
Two
Malad.
things, Malad, regarding the, I distinguish the judgment, Malad, in case of Sri Shubhendu Adhikari, but I've just made a chart, Malad, indicating the relevant paragraphs. And Malad,
My lords, I have one last plea. My
and
lords,
Malad, only one thing, Malad, one judgment, Malad, that remained not cited by me, Malad. It's reported in 2009, 5 Supreme Court cases.
Interim order passed earlier stands extended till 31st August 2026 or until further order, whichever is earlier. Stop. List the matter under the heading. List the matter under the heading for order on.
loaded. Yes.
25th August.
Malad, may I do this, Malad?
Can I have a small plea, my lords.
Can one
small-
for extension?
Malad.
Let it be disposed of. Yes. Give the
My lords,
number.
He has sought for extension till
Application 26, filed by the petitioner seeking extension of interim order, is disposed of.
no
Manoj, I
extension
have one more request.
till
Manoj.
disposal of the writ petition. That is the prayer in the can.
That is in view of this order that is disposed of.
But may I Malad only one? But may I submit a small note by Thursday? May I submit a small note by Thursday? That will actually aid in passing of the interim order.
If you can, court is not directing. If you want, you can.
I will, Malad.
Yes.
Manoj, I have one small request.
Sauce
One
for the
small
gander
request.
is sauce for the goose. They did not hand me over a copy, Malad. If they hand me over a copy, I'll give them a copy.
No, we'll hand over. There's no
Don't,
question.
Malad, I won't.
We'll hand over. We'll hand over, Mr. Bhattacharya. It's my responsibility. I'll make sure it's handed over. Manoj, may I make a request? I can't hear what.
Yes, Mr. Shankar.
One small request. The
Yes.
16 FIRs that my friend has handed over, we
Yes.
have checked. We have checked on the website, Manoj. The first page of the FIR is there on the website, but the underlying full FIR with the complaint is not available. I was just wondering because we have made efforts going to the police stations and trying to obtain it. That has not been forthcoming. If some way your lordships could just encourage them, if they could just share those copies with us, that I don't want to trouble the court with them filing, etc. Just give us permission. Our lawyer will go to the police stations and we'll make requests and it can be given to us.
I
You are not.
don't know. It's come sudden. It's coming sudden.
Uploaded, Malad.
It's coming suddenly, Malad. I cannot, Malad. I can. They have to apply, Malad, with the GN number.
It's not
With the GN number. They have to. They have the numbers. They have the numbers, Malad. They have to apply for with the GN number for a certified copy. That is the system. I am not teaching anything, Malad. Since new proposition of law is coming, Malad.
It is not there in the portal.
Malad,
Before the next date, concerned police authority is directed to supply copy of all the FIRs in connection with existing criminal prosecutions to the petitioner.
I'm most grateful.
but
With the complaints, Malad.
But that is not,
Those are not
but that
uploaded.
is not a prayer here, my lord. They have filed a separate writ petition.
It is a prayer.
They have,
It's prayer
they have
G.
filed a separate.
It is prayer G. It is prayer
They have
G of
filed
our
a
petition.
separate writ petition also now, my lord.
It's prayer G of our petition.
But they have to apply for certified copy, my
Mr.
lord.
Bhattacharya, you are appearing for whom?
I am for the state, my lord.
Mr. Raju has appeared.
Sir has also
creating
appeared.
difficulty.
No, I will indicate, my lord. 3 to 13, my lord.
Please clarify it. Please clarify it. Because your name and Advocate General, Learned Advocate General's name were transcribed twice.
Yes. For respondent number 1 and 2,
3 and 13.
for respondent number 1 and 2, the Learned Advocate General is leading me, my lord. And for respondent numbers 3 to 13, my lord,
Mr. Raju.
Mr. Raju is leading the team, my lord.
But you are both of you, Learned
Yes.
Advocate General and Additional Advocate General, are appearing in both on behalf of respondent number 1 and 2 as well as 3 to 13. Yes, there is no dispute with regard to your appearance.
So, my lord,
We are also not raised.
my lord, let them indicate the FIRs they need, my lord.
16 FIRs.
16.
You have given the chart
Yes.
in terms of previous order. So supply them copies of the FIR and complaints before the next day.
Very grateful, Manoj. I'm most grateful.
Very great.
Manoj, I'm sorry that we took so much of your lordship's time, but very
But I
grateful.
have handed up that chart, my lord, distinguishing the chart is there, and my lord, another judgment, my lord, that I tried to indicate that in the note. Note indicate করে দেবো সুবিধা হবে যশোর কিসের রে না ওটা দেবো
Yes, you are all of you are released because I will rise for 10 minutes. Let me arrange papers in according to my own way.
Grateful, Manoj.
Yes. এটা এখানে রাখো তলায়।
Under the next matter, the report was to be filed.
Just এর একটা ইয়ে কোথায়?
না এটা নেই গো পাড়ার ব্যাপার তো তাই নেই
ছবিটা ছিল না?
ও হ্যাঁ,
পছন্দ করি না
next
কিন্তু
door neighbor.
হ্যাঁ
তাহলে আমার নোটস কোর্স গুলো আমি নিলাম না। দেখো ওই ফোল্ডারটা দাও তো, লুজ ফোল্ডার। হ্যাঁ দাও দাও দাও, লুজ ফোল্ডার হলে দাও, এটাই হবে। এটা তো এইটা সাদাটা।
আচ্ছা আচ্ছা তো
সাদাটা দাও। এটাই খুঁজছিলাম।
সবাইকে আগের দিন সার্ভিস জমা দিই। এই তো সার্ভ করেছি। না না করতে হবে।
Till 17.
Yes, yes, Mr.
The next one, my lord, the report was to be filed.
And I'm
Yes.
for the petition.
But
And I'm also for extension of interim order, my lord. We have filed a can, my lord, upon service
দেখি
to
দেখো তো।
all my my lord friends.
Item number 3.
Because advocate general is there for
Lordships,
is
lordships.
here in the from morning.
Yes, yes,
But
absolutely.
this will not take time, my lord. That is why.
My lord had
That
called,
matter. That
my
matter.
lord had called for a report, my lord.
Two reports.
Two reports, which is reflected from the last order also. Thrice we have complied.
So interim order is till 17th.
Till 17th, we have filed the can, my lord, for extension of interim order, my lord. And
Yes, file your reports, Mr. Mitru.
And appeal was preferred, intercourt appeal
yes,
was
by the
preferred.
de facto complainant.
Yes, what is the fate of
That is coming up
That
on
is pending.
27th of August, 27th or 28th.
You are representing. De facto.
No, 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 my lord. We are
I am
the respondent.
defending the de facto.
Mr. Chana is for the de facto. He is the appellant before the my lord division bench. And that appeal, my lord,
Let me extend the interim order for some time and
Lordships.
taking the reports on record.
Lordships. The appeal is coming up on 28th.
In the meantime,
since
the
I am-
order is, if any order is passed by the appellate
We'll-
court,
we'll
then that will be
communicate.
considered by this.
My lord, since I am the de facto complainant as well as the victim, my lord, may I get a copy of the report?
But then the
My
report can be,
no, my lord, my
can be
entitlement
circulated
to
to
get a
all
report
of us, my lord.
is always
No,
there.
no,
In one
he's-
matter where I directed Bidhannagar Commissionerate, Commissioner of Bidhan, I directed that will be only for the consideration of this court.
No, my lord, kindly sees the
He's an
see the
accused
order.
also in another case.
My lord, kindly sees the report. Kindly sees
One
the
is
order.
by the Director General and Inspector General of Police West Bengal. Being respondent is directed to submit a report disclosing progress made in the investigation.
No, my lord,
That
kindly comes
will
to the
get.
first order. The first order dated 10th June. My lord, kindly comes
But
to
the
paragraph
Commissioner of
32.
Police, Bidhannagar Police Commissionerate, that is for the for consideration of this court, you will not get this.
My lord,
He's also an accused in another case relating to the same event. So, my lord, he
no,
also.
I am accused in connection
Yes,
with
yes,
that
where
case.
the
My
report-
case,
But
Mr.
my lord,
shielding
the
himself.
direction was there
Where are the reports?
to make an independent inquiry as to
Mr.
why
Mitro,
event could
where
not
are
be
the
organized appropriately. That was the
Where are the reports?
My lord, I have the report of the Commissioner of Police, my lord. The DG report was.
এটা ছিল প্যারা 28 এটা 32 এটা 28
If it is not ready, then take time.
No. So far paragraph 20 it is concerned, my lord, I am not entitled. But so far paragraph 32 is concerned, my lord, kindly, my lord,
not
consider
at
my
this
prayer.
stage. Not
No,
at this
so far
stage.
paragraph
That is not
32.
that is not a case made out in this writ petition. It is for the court. Court has made certain observations with regard to that event to satisfy consent of this.
My lord, subject to
Directly,
correction,
yes.
subject to correction, my lord, this has a direct bearing with the allegations that has been made by the victim.
Maybe
For paragraph 32 is concerned.
let the
Yes, whether
investigation
reports are ready,
conclude.
no. File it.
The de facto cannot be a backseat driver, my lord, with greatest respect.
ওটার একটা কপি স্যারকে দিয়ে রাখো। Please. এছাড়াও রয়েছে
issue.
My lord, may I submit
Also,
only-
terms of the order
My lord, may I make a
24th
very
August
small submission?
2026. Mr. Surajit Nath Mitra, Learned Advocate General, representing state respondents, has filed, has filed two reports. One is dated 3rd August 2025, 2026 of Director General and Inspector General of Police West Bengal, and another is dated 10th August 2026 of Commissioner of Police, Bidhannagar Police Commission, comma, those are taken on record. Next paragraph. Late copy of the report dated 3rd August 2026 of Director General and Inspector General of Police West Bengal be made over to the learned.
Your lordship wanted to know, my lord, kindly for the time being, kindly.
No, regarding Bidhannagar Police Commissioner's report, I am not directing you to circulate. Only the report of DGIC. Because that was regarding the observation made by this court with regard to that incident happened in December 2025.
There is no other
Ah,
case pending against him.
Made over to the
What
learned
is the
advocates
report, the progress of
representing the
case?
petitioner and respondent number 5. Next paragraph, interim order passed earlier stands extended till
My lord, kindly come to the report once. The last page.
which report?
The DIG.
Second page, meaning by the second page of DIG report.
No, the
DGI.
annexure.
Karuna, এই রিপোর্টটা দিতে বলেছিল। একটা, whether there is any other pending case
Yes.
against him or not, and secondly, what is the progress of investigation? There is no other pending case against him, but progress of investigation, they are not available, they are not supposed to get it right now.
Well,
No,
the
no,
report,
so the
report
fact
which
is
your
that I
lordship
am-
called for in terms of para 28. My lord, only I'm asking myself, my lord, what business would the respondent number 5 have?
My lord,
in
I
having
have.
that report, my lord.
My lord, may I
28, I am not directing to circulate this report.
Lordship.
Only DGIG's report I am directing.
Yes, in paragraph 28 only, my lord.
That is para 28.
28.
That is para 28.
DGIG
my lord.
report.
Yes.
Page,
Statements are the statement.
My lord, the last page, my lord. for
page
something.
7 of Deputy Commissioner of Police, Bidhannagar Zone, dated 3rd August 2026.
Lordships.
Yes.
My lord, second paragraph at the top, be it mentioned.
No, my lord is looking in the to the order.
Has been fixed on so date. E statement and now they are not supposed to get it done. It's the stage of investigation. 164 statement never also.
এখন ওরা জানবে না
And my lord, the penalty.
Just a minute, and not to take any person steps. Institutions. Okay. Institution. It is on June, 18 June. I don't think that is correct
13th.
because this order was passed in the month of August, 4th of August.
As per the order, my lord.
10th of
No, no,
June, my
10th
lord,
of
had passed
June, the
the
first order.
10th of June.
the first one
Yes, yes.
And then the next
And
paragraph.
that's an statement.
Recording.
Statement was recorded as a submitted. Statement.
investigation.
Yes.
The paragraph starting with recording of
Yes.
the name is mentioned. My lord. The name is mentioned, my lord, who would be interrogated the particular sentence. So, my lord,
So that's why you are praying not to circulate.
not to start.
My lord, the report.
Made over.
No, my lord, may I just submit one thing, my lord, subject to correction
He's an
and
accused
exception.
in the same case.
My lord, I am not an accused.
He's on bail in the first case.
Extended.
Interim order passed on
10th of
June
June.
2026.
My lord, so far, my lord,
Extended till 30th November 2026 or until further order.
Only one submission of mine can be recorded that pursuant, there was a condition of your lordship's order that I must comply with all notices. I am giving your lordship 3 dates, my lord. 18th of June, 22nd of June, and my lord 7th of July. I have annexed those also, my lord, in my can. Pages, my lord, 15 and 16.
You appeared.
I have appeared.
Yes,
and
yes. That is reflected from the report itself.
Very best, very best. My lord, that I do not know, my lord.
my lord, I have a very small
Short-
submission,
short-
very short submission.
Not
Vacation intervened in the meantime. Prior to vacation, several matters are fixed. Come back on 30th November.
And I have been complying.
On 30th November 2026 or until further order, list the matter or until further order, whichever is earlier. Stop. Next paragraph. List the matter under the same heading for further consideration on 17th November 2026.
and my lord, it will not.
Application being Can 1.
Can one.
Application being Can 1 of 2026 seeking extension of interim order filed by the petitioner is disposed of.
I'm deep.
My lord, I have a very small submissions, my lord. My lord, so far paragraph 32 of the order is concerned, my lord, I am entitled
No,
to get
today I will not direct to
My lord, so far paragraph
because
32
investigation is
my
going
lord,
on. Sorry.
my lord, because it has a direct bearing with my allegations.
He wants to
will not,
create
my
a
lord,
defense.
It will not preclude, my lord, filing of, my lord, charge sheet before the learned court, my lord.
My lord, your lordship cannot say charge sheet, my lord.
Yes.
Yeah, otherwise
Lordship
the
can-
scheme
your
of the
lordship
act,
can say
my lord,
report in
entitled
final
me.
form. Perhaps, my lord, subject to correction.
However, it is made clear that pendency of this proceeding shall not preclude the investigating agency to take steps with regard to ongoing investigation and to file report before the jurisdictional magistrate.
Great obliged. ঠিক আছে।
ভালো তৃণমূল
Obliged.
On the last occasion,
Number, call who?
Please call the list.
item number 4. My lord, on the last occasion, my lord was pleased to call for a report. Asked them to seize the documents which I had alleged to be forged. The FIR has been pending since 4 years almost.
Yes. Report. Whether authorization letter and agreements are seized.
There is some catch in this, Lordship.
Which page? Which paragraph?
Lordship, may kindly, there's a page which I have dog-eared. If my Lord may kindly take up that page. B9, that is annexure B9.
B9 and B10.
B8, my Lord may kindly take up B8, the page previous to B9. A notice was sent to the district controller, Food and Supplies Malda, for original copies of the agreement.
Third page.
No, Lordship, annexure B8.
Oh.
Annexure B8. I have dog-eared the page, Lordship. The page prior to that, if my Lord can kindly look at.
B9.
B8 first and then thereafter B9.
Yes. Just a minute.
একটা করে দেখাই।
Yes, this is the letter for by which police
This is
authority
one of the
requested for supply.
first letters. Lordship may kindly turn over the page.
Yes, B9.
The person who had in his custody these two documents.
Just a minute. This is the response of to your letter.
This is not per se the response. The response is later on. I want to show this page to bring on one fact.
How missing of Hirak Ghosh is relevant?
It is relevant because these documents were with him. Lordship, I am not trying to shy away or anything. My lord may also take.
What is he is working in
Yes.
food and supplies department?
Yes, he's the food inspector with whom apparently these documents were in whose possession these documents were in. Lordship, I've spoken to senior officials with respect to this matter. I will require some more time. There is something that more does not meet the eye.
But how
If I may indicate,
please, how police comes to a conclusion that these documents are lying with Hirak Ghosh?
Because he was he was the official who was in charge of that department and who he was at the material point of time, and it was handed over. My lord may kindly take page 11, B11, annexure B11. It is mentioned how Hirak Ghosh had come into being. It was produced by him and it was again given on Jimannama bond back to him.
But different case number is stated 315 of 2023. But it is in case number Harishandrapur case number 1141 of 20.
That is the case against the petitioner. This document is relevant for both cases.
There are two cases.
Two cases, case and counter
case.
Case and counter case.
But in counter
case and counter case,
2023, charge
sheet has been filed.
So then how it is relevant?
It is relevant in the case which is pending basis the complaint of the writ petitioner. Kunta.
It was under Jimma of
Hirak Ghosh.
He is the complainant in that case against me. 2022, I filed the case, my lord, saying that my signatures were forged. I had resigned way back in 2016. 2022, this director forges my signature and procures a food supplies order and then defaults. Then defaults. And then the food supply goes on to file a case against me as well as the other directors. And my case is not being investigated. Hirak Datta had custody of all the documents, my lord. He files the case against me and and he submits the charge sheet. And my case remains lying for 4 years.
It is wrong to say that it is not being investigated upon. It is being investigated upon. I am not joining issues with my learned friend here. I can understand what is going on, at least from a bare perusal. B13, Lordship, if my lord kindly takes a B13, that is also very material. So now I have roped in the food and supplies department also. I've spoken to the higher officials in that department also. My lord kindly, if my lord may give me at least 14 days time, I can find out, because these are all legacy matters, as my lord may know. So
yes.
These are all legacy matters, baggage of legacy. B13.
B13.
And I am facing criminal.
Now they say that this document is not there in the office. একদমই ঠিক করে দাও।
Now, if police knows that the documents, this agreement and authorization letter are lying with Hirak Ghosh, then why those documents were not recovered during such a long time from 2022 till 2026?
And the irony is, my lord, I am
My lord
filing a
now
criminal
understands.
prosecution based on.
I believe my lord now understands the
Just
necessity
state.
for custodial interrogation in some cases.
I'm not recording anything.
No, my lord, kindly gives me
Issue.
14 days. I will
Issue. In terms
look
of
into
order
this.
dated 8 July
May I get a
2026, a report
SP number.
dated 10th August 2026 of officer of sub-inspector Bhaluka outpost under Horishchandrapur police station, along with certain documents are filed and same are taken on record. Next paragraph. However, Mr. Das learned additional government Twitter, representative state respondents pressed for time to take steps in Horishchandrapur police station case number 1141 of 2022 dated 28 December 2022. In terms of order dated 8 July 2026. Stop. Petitioner is represented by learned advocate. Next paragraph. Acceding to the request made on behalf of the petitioner, hearing of this matter stands adjourned. Stop. List the matter under the same under the heading new motion 1 on September 2026. Huh? State respondents. Right.
And may I request one thing, my lord? In that 315 case, my lord, can my lord directs them not to take any coercive action against me, my lord?
No, sir. That's too big. That is beyond the jurisdiction of
The warrant is pending in that.
Oh, sorry. Next matter. You take steps for that.
Item number 5. ইয়ার আছে তো একটা ফাইল করা।
Five, my lord, appears for the petitioner, my lord. My lord, the live streaming may be paused because this relates to sexual offences, my lord.
লাইভ স্ট্রিমটা বন্ধ করো।
6.
My lord, I appear on behalf of the petitioner, but there's no respondent here, my lord. There's no private respondent in this application. But this matter concerning, my lord, police inaction, the accused would not have any say in the way the investigation proceeds.
Just a minute.
My lord.
Yes. What you are paying for?
Lord, I'm praying for, my lord, transfer of investigation to the detective department. But my lord, your lordship will kindly not grant me that, my lord.
Already FIR has been registered.
FIR has been registered. my lord,
Registered on
post-
10th March
Yes, my
2026.
lord. What I am aggrieved with is the inaction in investigation, not non-registration, my lord.
Matter is heard in presence of the learned advocates representing the petitioner and state respondents. Next paragraph. A case is made out in this writ petition whereby mandamus is sought for, thereby directing the police authorities to take steps in Tiljala Police Station case number 124 of 2026 dated 10th March 2026.
My lord, may I be permitted to submit?
Stop. It's not required. Please hear the order. Stop.
May I pray for just one indulgence, my lord?
Stop. Prayer is also made for directing the police authorities to file report before the jurisdictional magistrate on completing investigation. Next paragraph. State respondents are represented. You are for the both of you are for the state.
For the state. I'm for the state, my lord.
You are for
Private respondent number 629. ma'am.
There's no private respondent.
Private respondent number 629.
6 to 9.
There's
My
no
lord,
private
I
respondent.
have to pass
Private
this
respondent numbers.
629.
But I'm not
There are
adding
respondents up
Yes,
to
my lord,
5.
I need to disclose. My
There
lord,
are respondents up to 5. There is no 6.
my lord, kindly come to
There are respondents up to 5. Answer query.
Yes,
You are
my lord. Yes,
representing
my lord.
whom?
that thing has been done before this honorable court, my lord. Page
You are representing whom?
4, 6, and 8 page.
There is
Respondent
no
number-
6, 8.
My lord, may I explain?
My
my
lord,
lord?
page number
This is
4,
the
6,
second
and
round
8.
of-
Respondent number 6 to
My
9
lord,
is there.
there is-
My lord, kindly see. I am in the body. I am in the body.
My lord, this is the
They
second round of
they
writ
deleted the
petition.
name from the earlier writ, which was dismissed by
This is
your
the
lordship.
second round of writ petition.
With
The
the
first
to
writ
file
petition.
appraise, and what they did, my lord, they made a copy and paste second application.
Very well, that is their decision whether whom they will make party or not.
My lord,
If
kindly,
you are aggrieved, then make an appropriate application in accordance with law.
my lord, in the body of the writ, my lord, respondent number 4 and 6.
Well,
lord, kindly have a look at
respondents are
page 4.
represented by learned advocate. Next paragraph. From
And
the
there is a case and
made
counter
up-
cases also.
State respondents are represented by learned advocate. Next paragraph. It appears that petitioner is aggrieved by inaction on the part of the concerned police authorities in taking steps in connection with
Tiljala Police Station case number 124.
124 of 2026. Stop. There is an alternative remedy available to the petitioner under section 175(3) BNSS 2023 by approaching jurisdictional magistrate. In the event appropriate steps are not taken by the concerned police authorities while investigating the case. Stop. In this regard, reliance is placed on the judgment of the Supreme Court reported in 2026 SCC Online SC 798, Sujal Vishwas Attavar and another versus State of Maharashtra and others. Next paragraph, in paragraph 7 of Sujal Vishwas Attavar, it has been succinctly held that even that after it has been succinctly held post registration of FIR, if proper investigation is not conducted, then remedy does not ordinarily lie in invoking writ jurisdiction in the first instance, but party needs to approach within the statutory frame. Next paragraph. Next paragraph. In view of availability of alternative remedy, present writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach jurisdictional magistrate in pursuit of remedy.
I'm grateful.
To act on the server copy.
Grateful, my lord.
Next.
Item number 7.
Lordship, I'm for the petitioner.
Yes.
Lordship, kindly pardon me. In page number 5, para number 3, there is written respondent number 6.
You have to mention only one thing.
Please do not make any submission after matter is over. Enough is enough. Yes.
Lordship, in page number 5, para number 3, there is written respondent number 6. Lordship, kindly pardon me. It will be
Paragraph, page number 5.
5, para number 3, Lordship.
Just a minute. Paragraph, not para, paragraph.
Pardon, sir.
Yes. Paragraph 3, yes.
Respondent number 6, it is written, Lordship, it will be respondent number 7. That is clerical mistake from my side.
What is the matter about?
Matter is, Lordship, the petitioner and respondent number 7 was engaged in a business, Porado business. After that, the business dispute arose, and in 2023, petitioner was attacked by respondent
You
number
are praying
7.
for registration of FIR.
Lordship, yes.
Issue.
Your Lordship, I am for the state, Your Lordship. Thank
I
you.
have not called for. This is for your consumption. You are appealing for whom?
Advocate for
We are applying for respondent number 14. We are at
14. 1-4.
1 for private respondent number.
Matter is heard in presence of the learned advocates representing petitioner, state respondents, and respondent number 14. Next paragraph. By presenting this writ petition, by presenting this writ petition, petitioner has prayed for direction upon the concerned police authorities to register FIR based on complaint lodged. Stop. Next paragraph. There is an alternative remedy available to the petitioner under section 175(3) BNSS 2023 in the event complaint is not transformed into an FIR. So in this regard, reliance is placed on the judgment of Honorable Supreme Court reported in 2007-6 SCC 171, Aliu Padamsi and others versus Union of India and others. Next paragraph. In view of availability of alternative remedy, present writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach jurisdiction magistrate in pursuit of remedy. Parties to act on the server copy.
Item number 8.
My lord, I appear for respondent numbers 3 and 4.
But I am for the petitioner, my lord. Affidavit of service, my lord, may be taken on record.
Lordship, may kindly look into the prayers at page 8. Oh.
So you are dissatisfied with the investigation? There is
Yes,
a
my lord.
delay
Kindly come.
and inaction on the part of the police.
What they have done.
Approach the jurisdictional magistrate.
But the first prayer, my lord, is.
Forum issue.
But the first prayer is not at all applicable. Charge sheet has been submitted.
Charge
Charge
sheet
sheet
has
is
been
there.
submitted, but 2 persons who are main accused, they have been discharged.
Then you have a remedy under section.
Let him file an application for 5 years. Further investigation.
Court by filing a writ petition. It was previously 173(8). Now it is 193.
193(9) of the BNSS.
Yes, when charge sheet filed?
My charge sheet.
20.
28th of November 2025. It is annexed at page.
Report. Yes. It is Nagarbajar Police Station case number 10 of 2024.
My lord.
Dated 12th January 2024.
Charge sheet submitted on 28th of November 25. Case started against 5 persons. Charge sheet against 3 persons. 2 persons have been discharged from the case. Now, my lord, if they are aggrieved, they can always file an application for further investigation.
Matter is affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph, learned advocate representing petitioner submits that petitioner is aggrieved by inaction on the part of police authorities in taking the investigation of Nagarbajar Police Station case number 10 of 2024 dated 12 January 2024 to its logical conclusion.
prayer is made for issuance of mandamus directing the police authorities to expedite investigation and submit report. Next paragraph. Learned advocates, you are representing respondent number
3 and 4.
Respondent numbers 3 and 4 are represented by learned advocate. Next paragraph. Learned advocate representing state respondents has filed a communication dated 27 July 2026 of officer in charge Nagarbajar police station, and same is taken on record. Copy of the communication, copies of said communication are made over to the learned advocates representing the petitioner and respondent numbers 3 and 4. Next paragraph. It is disclosed in the communication that on completing investigation in Nagarbajar police station, case number 10/2024 dated 12 January 2024, charge sheet dated 28 November 2025 was filed before the jurisdictional magistrate. Stop. Are you aware of, Mr. Mitro, whether cognizance is taken by the court below?
Yes, it has been taken.
Stop. It is also contended. It is also submitted by on behalf of respondent numbers 3 and 4 that post filing of charge sheet, cognizance of offense is taken by court below. Next slide. Once cognizance is taken by court below, after filing of charge sheet, writ petition is not maintainable since judicial order intervenes in the proceeding. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court.
My lord, I am relying upon my lord one.
Supreme Court reported in 2024 SCC Online SC 5761 within bracket Nita Singh and others versus State of Uttar Pradesh and others. Stop. It needs to be recorded hearing that petitioner, that court, it needs to be recorded hearing that court is not considering, it needs to be recorded hearing. Neither court is considering application under Article 227 of Constitution of India, nor this is an application under Section 482 CRPC / Section 521 BNSS 2020. Stop. Once judicial order intervenes in the proceedings, writ petition is not made.
It is 528, my lord.
Yes, 528 I have said.
521, my lord, I heard, but I may be wrong.
No,
Oh.
528 I have said. Once judicial order intervenes, judicial order intervenes in the proceeding, writ petition is not maintained. Next paragraph. Hence, present writ petition is dismissed. However, this order shall not preclude the petitioner to take steps in accordance with law if so advised. Parties to act on the server copy.
Grateful, my lord.
Item number 9.
I beg to appear. In this matter, my lord.
My lord, I am appearing on behalf of private respondent number 4.
Milord, before your lordship rises, Milord,
Get full lordship.
Please call the list.
Item number 10. 10, my lord, I appear on behalf of the petitioner, my lord. I serve the copy of the upon the respondent concerns. My lord, the petitioner father-in-law, my lord, is originally recorded owner in respect of plot number 307, 3007, 3008, 3046, and 3051. The petitioner is belongs to Santal community, my lord. The respondent number 8, my lord, a powerful and very influenced persons, my lord, in the locality, and is using muscle power, my lord. He forcefully
for the respondents. When you have sub notice.
My lord, I serve a due serve.
देखिए हमें दो तो.
My lord,
no, what you are praying for?
My lord, I paying for, my lord, the respondent number 8, my lord. The take a step is according to
whether any FIR is registered.
No, my lord, I made a complaint, my lord, page my lord 17 P3. Thereafter I made a letter demanding justice, page 22 20. Lord, my land has damaged, my lord. The same land, my lord, is not cultivated. The persons are extraction of black stone in my land without any permission of the authority and me.
Where is your complaint?
My lord, page 17, P3. All authority I made a complaint, my lord, by hand. Page 19. They received.
Mr. Mukherjee, Moyuk Mukherjee, appear in this matter, obtain instruction. Nobody is appearing for the state in spite of service of notice. Issue. Affidavit of service filed on behalf of the petitioner is taken on record stop. In spite of service of notice, respondents are not state respondents are not represented. Next paragraph, Mr. Moyuk Mukherjee, learned advocate, is present in court, who usually represents state respondents. Next paragraph, Mr. Mukherjee is requested to enter appearance on behalf of state respondents. Stop. Learned government figure is requested to regularize engagement of Mr. Mukherjee on behalf of state respondents. Next paragraph, learned advocate for the state is directed to obtain instruction. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 27th August 2020.
Debriefing.
Next.
A copy যদি পারেন
Debrief.
Item number 11.
Item, Your Lordship, led by Mr. Somonag is before his legs, Your Lordship, praying for short passover, Your Lordship.
Yes.
Mr. Somonag, led by Mr. Somonag, praying for short passover, Your Lordship.
Not today.
Wait.
Not today.
Wait.
Item number 12.
Lordship,
Milord, in item 12, Milord, I appear for the petitioner. Milord, I appear for the petitioner.
Yes.
Milord, I was only praying, Milord, if your Lordship may kindly take up this matter on some other day, if it could be, Milord, on the 19th, Milord, subject to the business of the court permitting, Milord.
Yeah, for the state. I am for the state. 19th.
19th, Milord, subject to your Lordship's.
Well, 19th August. Recorded at the time of Mr. Kishore Dottal and senior advocate representing the petitioner appears on virtual mode. State respondents are represented by Mr. Rajdeep Mojumdar, learned additional advocate general. Next paragraph. On behalf of state respondents, accommodation is prayed for. Stop. Hearing of this matter stands adjourned. list the matter under the same heading on 19th August 2026.
Your Lordship, if the affidavit of service be taken on record.
Affidavit of service filed on behalf of the petitioner is taken on record. Definitely. Next.
I'm grateful, my lord.
Item number 13.
Item number 13, my lord, I am for the petitioner here. My lord, petitioner made my lord application.
Your Lordship, in this matter, I appear for private respondent number 15.
Who is for state?
My lord, it is a lawful owner and possession of the schedule mentioned lands, seeking my lord in protection of his possession and my lord enforcement of the subsisting interim order passed by the Honorable Supreme Court as well as the Honorable Tribunal. My lord, I am the member of the Bhumijibi Sangho, my lord, which challenged the constitutional validity of the petitioner under section 14T3. My lord, that is the Honorable Supreme Court several order passed the status quo as regards possession without, my lord, in proceedings initiate but not final order passed.
You are praying for a direction upon the private direction upon the police authorities to take steps which would prevent private respondents from encroaching your land.
Encroaching, yes.
So what police authority will do?
Police authority, my lord, the Supreme Court, my lord, repeatedly says that no third party interest create. My lord, I am approach the BLRO detect the who is my possession.
Then approach the group 1 bench. What police will do? Is it the duty of the police authority to decide the rights of the parties?
Kindly appreciate my police authority, my lord. Direct the.
What is your submission?
Submission, my lord.
Yes.
For that, my lord, my predecessor, my lord, I am appearing, my lord, to private respondent. Respondent number.
Yes. What is your submission?
Before that, before vesting, my lord, my predecessor was the patta holder in one plot. And another plot, he is the recorded owner, and my client's, my lord, he was residing in the said plot of land for long years. That's why that application is not maintained.
Kindly see the Supreme Court order, my lord. Several order passed.
In your matter?
Yes, my lord. Now, my lord, Bhumijibi Sangho. I am a member of the Bhumijibi Sangho, and thereafter, my lord, Honorable Tribunal, my lord, Tribunal. Kindly see page 23. Page 23. Page 33, my lord. Page 33. The liberty is granted state Purva Bardhaman granted directly. Page 32. Page 32 to avoid multiplicity.
Where is the order of the Supreme Court? Where is the order of Supreme Court?
Kindly see.
Would be question, my lord, whether he has filed the application before the Supreme Court or not.
29.
Page 29.
29. Page 28, 29.
The 2000 order.
Yes. Thereafter, my lord, several order was passed, my lord. Kindly see. Page, my lord, 30. Vesting order has been passed in respect of the lands named petitioner Sangho who were before the High Court, out of which the present proceeding has then those vesting orders shall not be implemented until further order. That is the 14T3 proceedings, my lord. Thereafter, I approach the Honorable Tribunal. Thereafter, I approach the Honorable Tribunal. Honorable Tribunal passed an order to avoid multiplicity, to avoid the future application, conflicting judicial decision. We are the considered view. The interim order of stay, the impugned order 22nd February 2020 should be passed. Impugned
So your
order
contention that vesting order in favor of the petitioner was passed, which is non-est in view of the order passed by the Supreme Court on 17th April.
Yes.
Affidavit of service filed on behalf of the petitioner is taken on record. File your affidavit of service.
Yes.
Next paragraph. Learned advocate representing the petitioner prays for direction upon the concerned police authorities to take steps which would prevent the petitioner, which would prevent private respondents from encroaching land of the petitioner. Stop. It is submitted during course of reliance is also placed on order of the Honorable Supreme Court dated 17th April 2000, passed in special leave to appeal within bracket civil close bracket number 1416/1997. Stop. Next paragraph, learned advocate representing state respondents and
Respondent number, my lord. 10 and 13.
And respondent number 10 and 13 are represented by learned advocates who have opposed this writ petition. And it is contended that the issue involved in this writ petition relates to land dispute. Next paragraph. On perusal of the order of Honorable Supreme Court dated 17th April 2000,
And a recent order also passed.
it appears that
And also, my lord, recent order.
Number two.
which was passed on
Well, let's kindly see the recent Supreme Court order
bracket number 1416 of 1997, referred by Paschim Bongo Rajya Bhumijibi Sangho and another. Lines is placed. Okay. Now, it is found that hasting orders issued in respect of lands of members of petitioner Sangho in that special leave to appeal or special leave petition. Special leave to appeal.
I made a party Bhumijibi Sangho member, my lord.
Resolution number 15.
Who were before the High Court in connection with matter out of which special leave to appeal was preferred. Or special leave to appeal arose. Was directed not to give effect. Was directed not to be given effect.
And also, my lord, recent, my lord, one order, recent order was passed by.
দেখেন পাশে দিয়ে দাও shall not be given effect to করো until further. The sentence কি হলো? was এর আগে একটা comma. It is contended on behalf of petitioner that parta which has been granted in parta which was issued in favor of private respondents was in the teeth of order of the Honorable Supreme Court dated 17th April 2000. Stop. Next, in the event petitioner finds that parta issued in favor of private respondents cannot survive in view of the order of the Honorable Supreme Court. In that event, petitioner needs to approach. In that event, petitioner to take recourse to law. Stop. Police authority is not the authority to decide validity of parta if issued in favor of private respondents. Next paragraph. Hence, present writ petition is not interfered with and same stands dismissed. However, this order shall not preclude the petitioner to take steps in accordance with. Take it back. I have not called for any report.
Madam, kindly see the last.
Next matter.
Lord, item
number 14.
Hold on fast. Wait. Yes.
My lord, I'm praying for a short passover, my lord, and item number 14. I'm for the petitioner.
Next Monday. Next.
I'm good.
Record an order. Order could not. At the time of call, accommodation is paid for on behalf of the petitioner. Hearing of this matter stands adjourned. Stop. List the matter under the same heading on 17th August 2026. However, it is made clear that no further adjournment shall be granted on the next date. Next.
Item number 15.
Sir, I beg for the petitioner.
State respondent.
I am for the KMC matter.
State.
They have part at party.
KMC is not the party. Yes. I have not called for any report. It is for you. Yes.
The petitioner before Lordship Milord filed a suit for petition. In that petition suit, Milord, the interim order was passed and subsequently final order was passed, directing the parties Milord to maintain.
Final order passed means it was decreed.
No. Final order Milord in respect of Milord injunction application. Milord, the past Milord directing the parties to maintain status quo as regards nature and character of the property in question. Thereafter, Milord, an application under Order 39 Rule 7 was filed. The commissioner was appointed under Order 39 Rule 7 of the CPC for Milord local inspection. Was filed, Milord, commissioner was appointed, Milord, commissioner submitted a report in the civil court. Now, Milord, when this interim order was continuing, Milord, respondent number 5, they are making construction over the property in question. Milord, what they have done, Milord, they filed a writ petition before this honorable court alleging police overaction. Now, when the matter was taken up by your lordship, Milord, they took an adjournment. Now, Milord, that writ petition is hanging or pending before your lordships. Now, what they are doing, Milord, they are making construction. Milord, police is not taking any steps. I, Milord, lodged a complaint to that effect. Look here that they are changing the nature and character of the body in question. Police is saying their writ petition is also pending.
Whether it is running in the list.
Yeah, Milord, kindly see, Milord, page, I have paragraph 7, page 5. I have
no, whether the writ petition is running in the list.
Running in the list. Not running. Not in the list, Milord. But kindly have a look, Milord, one paragraph and so to lordship, page 5.
What is the order passed in that writ petition?
No order was passed.
Simply action.
Well, they simply asked for an adjournment.
No, if it is filed before me, it must have come before.
Yes, yes.
So what was the order passed?
Order is, Milord, they prayed for time, matter was adjourned. Bas.
On that score, my lord, your lordship, my lord, change of my lord, the state advocate matter was my lord, called on by your lordship. Thereafter, matter was adjourned and take instruction. That was the my lord, last order.
Now, Milord, the problem is, Milord,
is it appearing in the list?
No, there is no.
Okay, it can be tagged with that order also, with that writ petition. Milord, I have given the description.
You are the petitioner.
I am the petitioner.
Page 5, paragraph 7, Milord, I have stated. But my innocuous prayer, my lord, that let the civil court order be implemented by the police. My lord, this is the final form.
No, civil court order, if it is there under order 39 rule on 1 and 2. In that event, if it is violated, if you have to file an application under order 39 rule 2A, rate with 151.
Problem is, my lord, your lordship, can you visualize the situation? They filed an petition alleging police overaction.
Where is the order?
My lord, can you see, my lord, the order passed, my lord, by the civil court, my lord, appearing at page 21. Page 21. Well, last paragraph.
No. Final order.
Final.
Yes, very good.
I'm just pressing last. Having heard the plaintiff side and perusing the case record, it appears the suit.
Yes, come to page 22. Parties are
Yes.
directed to maintain status quo
Yes.
in respect of
Yes,
the nature
yes.
and character of the suit property.
Yes. Now, my lord, after that, my lord, kindly have a look, my lord, one.
Mr. Tewari, no right accrued in favor of the petitioner, even at the interim stage. Status quo order is meaningless order.
No, my lord,
Without defining
who is
the right of the parties in respect of the suit property. There is a judgment of Justice Dotto in Soumitra Bandyopadhyay and another.
That judgment, my lord, kindly, my lord, have a look, my lord. I may just place that judgment also. But before that, my lord, kindly have a look, my lord, PR Muralidharan once.
Yes.
PR Muralidharan once.
Yes, this was considered in.
Yes. The PR Muralidharan said, my lord, if even at an interrogatory stage.
Yes, if any decision is taken in an identical situation, it was before the coordinate bench in Soumitra Bandyopadhyay and another, where same set of facts, order of status quo, and court held that this is a meaningless vague order. Status quo order is nothing.
No, my lord, kindly visualize the court has said, my lord, the status quo in respect of the nature and character of the suit property till the disposal.
Unless until you define that what is status quo, what is the position at the same time, it does not bear any meaning.
No, my lord, kindly have a look, my lord. In that case, my lord, I have to read out the entire order.
I have seen the order. Please don't waste court's time by
Kindly see, my lord, kindly see, my lord, 2 pages, my lord, page 42 and page 43, what they are doing. Kindly see, my lord. The order of the court is to be respected, my lord, by any means whatsoever.
Yes, sure.
But may I just, so far as my lord, your lordship, my lord, Justice Dr. judgment, my lord, may I just place it, my lord, kindly have a look, kindly give me, my lord, 2 minutes, my lord. Kindly,
by presenting affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. By presenting this petition, I will also rely upon Justice Dotto's order.
My lord, I'm just, that's why, my lord, kindly give me, my lord, 2 minutes time, my lord.
By presenting
Justice Dr. only on different aspect, my lord.
Prayer is made.
There is one addendum, my lord.
Prayer is
Justice
made
Dr.
for
judgment, my lord, based on addendum order.
For
final disposal of.
For implementation, yes, that was addendum
Yes.
injunction. Ex parte addendum order.
Yes,
in your case, it was a final
disposed of.
Even then, you will find in that judgment, that's why I am not permitting you to read it out. You will find it in that judgment that it was in connection with status quo order.
Yes, I have
and
seen.
the status quo order without defining the rights of the parties in connection with the suit property is vague order.
May I just submit one?
Yes.
Kindly, has I know that. Kindly, 1 minute. In a partition suit, you also kindly visualize.
By presenting this petition, petitioner has prayed for issuance of mandamus, directing the police authorities to take steps for implementation of the order dated for implementation of ad interim order of injunction dated 2nd June 2025, passed in title suit number 69 of 2025. Stop. It is submitted that violating order dated 2nd June 2025, private respondent.
Only singular.
Private respondent is making construction changing nature and character of the suit property, which is contrary to the direction as contained in said order dated 2nd May 2025. Next paragraph, state respondents and private respondent number 5. Which respondent? Private respondent and respondent number 5 are represented by learned advocate. Next paragraph. On perusal of order dated 2nd May 2025, 2nd June 2025, it is found that parties to the suit within bracket TS 69 of 2025 close bracket were directed to maintain status quo in respect of nature and character of suit property till disposal of the suit. Stop.
This order was also
so this is a final order passed
on conclusion on final order passed on an application under Order 39 Rule 1 and 2 of CPC, but petitioner has a remedy, alternative remedy under section under Order 39 Rule 2 capital A read with section 151 CPC. Stop. Moreover, nature of order which was passed by the civil court is directing the parties to the suit to maintain status quo. Stop. Status quo order without defining right of the parties over the suit property does not crystallize even at the interim stage, or does not confer confer right upon the parties even at the interim stage. Stop. In other words, in view of order passed by civil court on 2nd June 2025. In other words, rights of the parties to the suit are not crystallized on the strength of said order dated 2nd June 2026, directing the parties to maintain status quo. Stop. If right of the parties are not crystallized, if right of the parties even at the interim stage is not crystallized, police authorities ought not to be directed to take steps for implementation of the order. Stop. In this regard, reliance is placed on the judgment of a coordinate bench reported in 2016 SCC Online Calcutta 2683 within bracket Soumitra Bandyopadhyay and another versus State of West Bengal and others. Next paragraph, before parting with, it needs to be recorded that petitioner has an alternative remedy to approach civil court under Order 39 Rule 2 capital A read with section 151 CBC. If it is found that order passed under Order 39 Rule 1 and 2 is violated. Next paragraph. Hence, present writ petition is not interpreted and stands dismissed. However, this order shall not preclude the petitioner to approach civil court in pursuit of remedy. Parties to act on the server.
So far as writ petition pending before your law, kindly consider that.
And you will find in Soumitra Bandyopadhyay, in your case, it is not similar case which was considered by the coordinate bench in Soumitra Bandyopadhyay.
Yes, I have seen.
In Soumitra Bandyopadhyay, after ad interim order was passed, an application was filed under Order 39 Rule 2A, read with 151, and there was an order for implementation of the order, and subsequently the writ petition was filed seeking direction upon the police authorities to take steps. But in the present case, without availing of the remedy which is open to you in terms of relevant provisions of CPC, straightway you have approached this.
Only one thing why I have
that is impermissible.
The other writ petition is pending, that is hanging on my head, shoulder, my lord. That writ petition is pending. Police is not doing anything. This is the problem. Otherwise, I would not have approached. Kindly see paragraph one. So far as this,
to that extent,
one observation. Kindly direct the police to maintain the peace and tranquility. One observation will suffice. Otherwise, what they are doing, Lord, by keeping this writ petition pending, Lord, they are.
Next paragraph at a line.
39, my lord, 39 for application.
Indicate particulars of that writ petition.
Yes. WPA 9834 of 2026.
9834.
Yes.
Of
2026. 2026.
It further appears from the submissions made on behalf of petitioner and respondent number 5. Respondent number 5 that a writ petition being WPA 9834 of 2026 is pending concerning same property, and that writ petition is preferred by the respondent number 5.
Alleging police
it is submitted on behalf of petitioner that due to pendency of this writ petition, police authorities unable to take steps. Stop. Next paragraph. It is clarified that pendency of writ petition being WPA of 2026
shall not preclude the petitioner to take steps in accordance with.
My lord, there is another observation. They are going to the my lord, executive magistrate. The executive magistrate set aside the order of the my lord, the 124.
Item number 16.
May it pleases your lordship, I'm appearing for the petition in this matter.
For the claims,
I'm appearing for Kolkata Municipal Corporation, your lordship.
My lord, affidavit.
You're appearing for Kolkata Municipal Corporation.
My lord, may I place my case?
Item number 2.
So you are seeking a direction upon the police authorities
Police authority.
I'm
for taking steps so that your right of the over the property can be preserved and you can have peaceful possession over the property in question.
my lord,
That is the sum and substance of your case. Now, in that event, you have to approach the civil court.
Lordship.
Yes, your lordship.
Petition, if court directs the police authorities to take steps in order to facilitate the petitioner to have peaceful possession or seamless possession over the property in question, then it is a roundabout way to get an order from the writ court which is not within the domain of writ court, because you are representing private respondents. Kolkata Municipal Corporation. Now, whether the private respondents have been made parties.
Yes, your lordship.
Therefore, they are required to be heard and your right has to be asserted before the civil court.
My lord,
Why the writ court will issue a mandamus directing the police authority
my
to
lord,
take steps?
may I place my case and explain what is the scenario?
Very
is?
nutshell in it.
Yes, my lord. My lord, I am a lawful occupant and I have been residing in this premise which is mentioned in paragraph number 2. I have been residing there since my birth, since 1967. I have annexed the documents which state my possession, your lordship. My lord, if my lord may come to page number 42, running page number 42, it is a legal notice which is sent by the private respondents to my brother. They have not sent any legal notice to me, and I have a reasonable apprehension that they will forcefully dispossess me from that
So it
property,
is your
my lord.
apprehension.
My lord, I am a cancer patient. I am in my 4th stage. I am actually going through a lot of my
No,
medical
but on mere apprehension, whether the writ court can pass an order anticipating some steps shall be taken affecting right of the petitioner.
My lord, my family member has received a legal notice, and in that legal notice, they are describing me as an illegal occupier.
And eviction.
And you have to challenge that notice before the bench taking corporation matters, group 5 matters.
My lord,
Civil in nature.
may I
Eviction
submit, my lord?
notice
I am
by
the petitioner in this case. May I submit my case, my lord? My lord, the illegal notice has not been sent to me. It has been sent to my brother, my lord. If it has been sent to me, I would have challenged that same in the appropriate legal authority, my lord.
That illegal notice which is sent to your brother will affect your right also. You have a right to challenge it.
My lord, right now, as I stated earlier, my lord, I am in my 4th stage of cancer, and
behalf of the petitioner is taken on record. Next paragraph. By presenting this writ petition, prayer is made for issuance of mandamus, directing the police authorities.
My
to
lord,
take
my humble prayer is
which
that
should
I should not be
facilitate the
forcefully
petitioner to have
I should not be
peaceful
forcefully
possession over the
dispossessed of
land
my property, my lord.
Stop. It is also submitted that petitioner apprehends based on notice issued by Kolkata Municipal Corporation. Petitioner might be affected. Next paragraph. State
Claims they have not issued.
Who has issued?
Private respondent have issued. It is an eviction notice, your lordship.
কি বলছিল?
It has been issued to my family member, my brother, my lord.
Issued by the private respondents to the brother of the petitioner. Petitioner might be evicted from the premises in question. Next paragraph, state respondents and Kolkata
We are Kolkata Municipal.
and he's for the state.
No,
you are
no,
for the-
he is appearing with me.
In this
Oh,
matter,
Kolkata Municipal Corporation is represented by learned advocate. However, state respondents and private respondents are not represented. Next paragraph, from the case made out in this writ petition, it appears petitioner is trying to assert his right over the property in question so that in future petitioner may not be evicted.
My lord.
Stop. Having considered the case made out in this writ petition, it is found that the issue involved is civil in nature, requiring the petitioner to approach appropriate forum. So police authority is not the appropriate authority to decide right of the petitioner over the premises in question.
My lord.
Next paragraph. Hence, present writ petition is not interfered with and same stands dismissed.
Your lordship.
However, this order shall not preclude the
Your
petitioner
lordship, even if
to take steps in accordance with law if so advised.
your
Next
lordship,
matter.
even if I am a trespasser, I should not be forcefully disposed as my lord.
Next matter.
Great.
Item number 17.
I appear for the state. 17.
This is a matter regarding my lord. My shop was forcefully
you are for the state
acquired, my lord, by some person. My lord. I sent all the responded, my lord.
Whether those persons have been made parties.
Yes, my lord.
Have you served notice upon
Yes,
it?
my lord. Delivered. Because, my lord, you should kindly come to my trade license, my lord. That is my father property, my lord. Page 15, my lord. P1.
Whether any FIR is registered.
Yes, my lord.
FIR is registered.
FIR was registered below initially.
But no steps taken, my lord.
No steps has been taken.
Tell me whether any FIR is registered or not. If FIR is
Yes, my
registered,
lord. FIR has been registered.
if FIR is registered, give me particulars of that FIR.
Under section.
হ্যাঁ নাম্বারটা কত আছে
নাম্বারটা আছে এখানে
কত আছে
P29 PS case number 87 of 2026
P29
87 of
where is your complaint?
Complaint, my lord. Firstly, my lord, that is, my lord, P2 page 20, my lord. That is my mother complaint. That is dated 5th of January 2025. And subsequently, my lord, next page, my lord, my deceased brother, my lord. That is next page, my lord, 23rd of June 2026. And then last complaint, my lord, that is 8th of July 2026. Several complaint has been made by the
just a minute. COP is closed for last 1.5 months.
This is untruly, my lord. False, my lord. Because, my lord, you'll have to kindly see the report, my lord. This is closed for the long 6 months, my lord. This is my property, my lord.
Is filed on behalf of the petitioner. Is
That
written on
report, my lord, this is a based report. Because, my lord, you should kindly the report, my lord.
that in spite of lodging complaint, necessary steps are not being taken by the concerned police authorities for initiating a criminal prosecution and to investigate case. Stop. Petitioner prays for issuance of mandamus directing the concerned police authorities to investigate case by registering FIR. Next paragraph, learned advocate representing state respondents has filed a communication dated 6th August 2026 of Inspector in Charge Balurghat Police Station, Dokhin Dinajpur, and same is taken on record. Stop. Copy of the communication dated 6th August 2026 is made over with the learned advocate representing the petition. Next paragraph, it is disclosed in the communication that till date no FIR is registered in view registered after preliminary steps were taken by the police authorities. Next paragraph. If petitioner is aggrieved by inaction on the part of the concerned police authorities in that event, petitioner needs to approach jurisdictional magistrate under section 175(3) BNSS 2023. Writ court is not an appropriate forum for ventilating grievance of inaction of the police authorities. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2026 SCC Online SC, page 798, within bracket Sujal Bishwas Attavar and another versus State of Maharashtra and others. Next paragraph. Hence, present writ petition is not interfered with and same stands dismissed. However, this order shall not preclude the petitioner to approach jurisdictional magistrate in pursuit of remedy. Parties to act on the server.
One and interest may be taken into consideration, my lord. Under 19(1)(g), my lord, that is right to business, my lord. That is
next matter.
My lord, kindly consider, my lord.
Item number 18.
For the risk.
This is a serious case, my lord. My wife has been, my lord, brutally, my lord, injured, my lord. You should kindly come to, my lord, my complaint, my lord. Section is very simple, my lord. That is also, my lord, objectionable under law, my lord.
How you have served upon private respondents?
Private respondent, I have served, my lord.
When served? Find it out when served.
Delivered, my lord.
When?
It was, my lord,
there are 3 private respondents.
5th of, my lord,
August.
This is a delivery report, my lord.
Of August.
Top of the mallet. Top mallet. Top 5th of August. Just I check.
No, this was sent to Director General of Police.
Habits were not there.
You need to tally the consignment number. There are 3 postal slips. One is sent to Director General of Police, another is District Magistrate, and another is Superintendent of Police. Where is the postal slip? So far,
Sorry,
service upon the private respondents are concerned.
I don't got maybe.
Extensive.
You are not a new entrant in this profession.
That is true.
So
Sorry.
court has to rely somewhere, somehow.
Yes, ma'am.
If this court is required to scrutinize
Yes,
your
that is-
affidavit
that
of
is-
service,
yes,
then it's difficult for this court
I am
to,
extremely
call to run this court.
extremely my lord. Sorry.
Now you are saying,
Because
I could understand that a junior is appearing before this
yes, I
court.
am messaging from
With responsibility, you are making submission that it was sent upon the private respondents on 5th of August. Court will never believe you. There are three postal slips. All are there are
it
three
was
postal
sent.
slips.
My according to my
There are
information,
three
my lord.
postal slips. All are addressed to police authorities.
Sorry, ma'am. Sorry, ma'am. I'm extremely sorry. It's my mistake, my lord. Sorry.
Take it back. ফেরত দিয়ে দাও। এসো। At the time of call, learned advocate representing the petitioner prays for accommodation to serve notice upon respondent numbers 6, 7, and 8. However, state respondents are represented here for the state.
Yes, my lord.
However, state respondents are represented by learned advocate. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon non-appearing respondents by fortnight from date and file affidavit of service on the next date. List the matter under the heading motion non-service in the monthly combined list of September 2026.
The report may be, my lord.
Nothing. Next matter.
Item number 19. My lord, I appear on behalf of the petitioners, my lord, my affidavit of service. Respondent number 10. My lord, if my lord comes to page number 24, my lord.
I'm for the state, my lord.
I'm for the respondent number 10.
My complaint, I had made a complaint before the police authorities dated 20th July 2026. Thereby, my lord, my allegation was that the private respondents are illegally cutting trees.
You are praying for registration of FIR.
My lord, subsequently, my lord, prayer B, my lord, if
Whether FIR is registered, who is for the state?
Has been, my lord. I have the
Yes.
Kindly, my lord, have a look. The FIR is also attached, my lord.
After filing of this writ petition.
No. Prior to that, my lord. Prior
My
to
lord,
that.
there is an analogous matter, my lord.
This is Bolpur PS case number 227-20 dated 14 September 2020.
Lordship will
14
find-
September 2020.
No, my lord. There's another, my lord.
There are two FIRs. Two FIRs, my lord.
One was there prior to, my lord. There's one.
One is dated 29 July 2026.
Absolutely, my lord. This is the one.
339-2026 dated 29 July 2026.
Absolutely, my lord. And investigation is going on, my lord.
Yes, it is after filing of this writ petition. Writ petition was filed on 27 July. So your grievance is redressed.
My lord, there is another writ petition pending, my lord.
Affidavit of service filed on behalf of the petitioner is taken on record. It is found from record that present writ petition is instituted seeking direction upon the concerned police authorities to register FIR based on complaint lodged. Stop. Next paragraph. Learned advocate representing state respondents has filed a communication dated 6th August 2026 of Inspector in Charge, Bolpur Police Station, and same is taken on record. Copy of the said communication dated 6th August 2026 is made over to the learned advocate representing petition. We are for the private respondents. Respondent number
10. 10, my lord.
Respondent is made over to the copies code. Are made over to the learned advocates representing petitioner and respondent number 10.
10.
Next paragraph. It is disclosed in the communication dated. It is disclosed in the said communication that based on complaint lodged, a criminal prosecution being based on complaint lodged, an FIR was registered being Bolpur Police Station case number 339/26 dated 29 July 2026 and investigation has commenced. Stop. In view of steps taken by the police authorities, no further order need to be passed on this writ petition and same stands disposed of. Next paragraph. However, this order shall not preclude the petitioner to approach jurisdictional magistrate in accordance with law if occasion so arises.
parties to act on the server copy. Next. Publish.
Okay.
Item number 20.
20, my lord, I am the state.
Private response. Item number 20, I am for the petition.
Yes.
My lord, I'll take your lordships through certain civil court orders, but then my prayer is not with regards to the possession. My lord, may kindly see.
But you are seeking direction for registering FIR.
Yes.
Where a
And inquiry. And inquiry. I'll tell you, lordship.
inquiry is to be conducted after registration of FIR.
The inquiry under disciplinary proceeding against the erring police officers. I'll tell you, lordships, why. My lord, kindly sees page 44 for once. Apparently, it might seem that I'm interfering, I'm invoking this jurisdiction in a civil courts matter, which is not the case. Page 44, my lord, I have secured an order where there was a direction of the civil court not to dispossess me. That was absolutely between me and the private respondents. Police had got no role to play with it. Thereafter, my lord, a series of, and this order was communicated.
You are the defendant therein.
I was the plaintiff in the title suit. But I am not with regards to dispossession here. Page 46, my lords, I have intimated the order out of my own volition to the officer in charge that this order has been passed. Subsequently, my lord, a series of 144, 107 proceeding by me and against me by the defendants. Thereafter, my lords, the averments, my lord, kindly seize my averments from paragraph number 9 and onwards in my writ petition. On 14/7, a police officer comes to my place of business. He takes me to the police station. He detains me throughout the day at the police station without informing me my grounds of arrest. He takes me to he does not produce me before the magistrate. He takes me to the local hospital. I have placed an RTI before the authority, hospital authority. They have replied to that effect. I'll produce before your lordships. And at night at 8:30 p.m. they say you may go. I am before your lordships for this illegal detention. I am before your lordship.
Prayer to the extent.
That is exactly why I have made one complaint. Lord, kindly seize my complaint and except P8.
Page?
That is at page 52.